Sheila's starting, isn't it? The clerk starts, doesn't it?
Yes, yeah.
Meeting open now?
We're showing 9:59, 10 a.m. We're just waiting for Mr. Cooper and Mr. Norn to join us. Fourth, 2021, and we are waiting for Mr. Cooper and Norn join us by way of video. I think I have Mr. Barclay here with me. We're ready to proceed, but we're waiting. Mr. Barclay, shall we wait a few minutes?
Let's wait a few minutes. We want to hear from Mr. Cooper, who's counsel for Mr. Norn, and we want to ascertain that Mr. Norn is here. So we'll give them a few minutes.
No, we're waiting. We're now sending an email to them to remind them to join the Zoom call, which we have sent instructions to them yesterday. I note for the record that I've had communication with Mr. Cooper via several emails this morning, so I do not know the reason for his not joining Mr. Barclay. Ms. McPherson, are you monitoring the calls of people who wish to join us? McPherson, do you know who's monitoring, whether they've asked Mr. Cooper or Mr. Norn has asked to join us?
Are you referring to me, sir?
Yes. Oh, I got the wrong name. I'm
Sorry.
Sorry about that.
I'm monitoring who is asking to join, and I don't have anyone waiting.
Apologize for using the incorrect name, Ms. McPherson.
That's no problem, sir. Mr. Cooper has just joined.
Okay, proceed.
Okay, so
Right there is a...
it says we're waiting in the waiting room.
Okay, there. I see Mr. Cooper's
On the left bar.
joining us. There you go.
Okay, when I stand up, so we're gonna have to tilt this up a bit more. Better?
Okay, good morning, Mr. Cooper.
Morning, Mr. Cooper. We can see you clearly.
Good.
And, Mr. Cooper, we don't see Mr. Norn having joined yet.
No, you don't. And I need to know the status of this broadcast. Do you prefer, sir, if I stand up when I'm addressing you other than my submissions, or am I
I'll
sitting?
leave that up to you, Mr. Cooper, whether you prefer to stand up or you prefer to sit. It's your decision. We're looking for all the assistance we can have from you.
Okay, thank you. And the moment I stand up, you can probably prepare for a more long-winded submission than when I'm sitting down, which is usually an indication of a summary bit of information. Are we public? I need to know that before I can address.
This is public right now.
Okay, I'm going to ask, sir, that as I did a little bit earlier this morning, we have a short private session in order for me to update you on the status of our ability to proceed.
I'm concerned about that, Mr. Cooper. This inquiry, as you know, is public unless there's an application where it has to be held in camera. And there's a series of authorities that reflect that it's rather critical that it is in public. So if there's anything that you want to say to me, it will be in public.
Sir, I understand that the legislation defaults to a public setting, but at the same time recognizes that witnesses, and in particular my client, have a right to some of the information being heard by you privately. I would suggest, sir, that this might be tantamount to a voir dire, where we will give you the information, allow you to consider the circumstances, and determine whether the matter has to be dealt with in public. The problem, of course, is that we cannot disclose the nature of our concerns, because that would defeat the purpose, which is the confidentiality and privacy of some very sensitive information that I'm obliged to pass on to you. And I'm not free to do that in a public setting.
Well, if I might,
I'm going to turn to my counsel, Mr. LaPrairie. What do you say about
well, the
that?
first thing that concerns me, Mr. Cooper, is don't see Mr. Norn on the screen.
I'll let you, Mr. LaPrairie, draw whatever conclusions you need from that fact, but I can assure you that it is connected with the reason that I want to address this matter in private.
But you are being instructed by your client for this request.
I am, and we've made this request known previously in a more general sense. I have specific information that will not be disclosed publicly. My client has instructed us to provide this information only on a private basis.
Mr. Cooper, I'm still very, very concerned. You look at all the case authorities involving a public inquiry. I take a lot of comfort in the learned author Ed Ratushny, who quotes a judgment of the House of Lords in England, where it says, the process of conducting open and public hearings is one of the essential features of commissions of inquiry that enhance public confidence. So I'm not at this stage going to turn this into a private session. You haven't given us any indication what reason you want it in camera. And so we're going to go ahead with having it in public. And there's a whole collection of case authorities, Supreme Court and the House of Lords, that publicity really is the very soul of justice, and it must be public.
Mr. Barclay, I advise you, though, that Mr. Norn is not present and needs to be present for this inquiry. And so I would ask that Mr. Cooper please indicate why Mr. Norn is not joining us.
That's a fair request, and I'd like to hear your answer.
I'm going to refer you, sir, as you made passing reference, to the provisions of the Legislative Assembly and Executive Council Act, specifically which gives you the authority to determine whether any hearing in an inquiry shall be conducted in public or in private. And the suggestion,
I understand that.
and the suggestion that the default is inherently public would seem to be in contrast to the discretion which seems to favor neither public nor private. For me to answer that question and comply with the instructions of my client, I'm not able to do so in a public setting, and perceive that my obligations to the adjudication are subject to the instructions of my client, and I cannot deviate from that. So I'm asking you, sir, to, in consideration of your discretion under Section 104 of the Legislative Assembly and Executive Council Act, to consider hearing this portion, or at least, might I suggest a compromise with you, the adjudicator, that the basis of the information be communicated to you in a private session. I would be able to give you greater information as to the circumstances which bring us to this particular issue if I can do that in public. I have no authority for my client to disclose any information in response to that question except in private.
What if I make a decision, though, after I hear from you that the matter should be dealt with in public, after considering your submissions and hearing the reasons why you want it in camera, and bearing in mind the legal authorities are to the effect that it should be in public? If I come to the conclusion fairly that it shouldn't be in camera, will your client then appear?
I understand, sir, that my instructions are to keep the information private. I would submit that I can stay within the confines of my instructions by giving you a very generalized outlook in a private setting. If that outline is disclosed publicly, it would be potentially harmful and prejudicial, but less so than giving it to you in a public setting. At least my client would have the opportunity to convince you on information that I can release in a private setting that I cannot and will not in a public setting. So in answer to your question, sir, in my view, my client would prefer, I should rephrase that, I only have the ability to release this information in private. If you subsequently decide to make it public, there's really nothing much that myself or my client can do in that scenario.
So at that stage, if I decide to make it public and your client, for whatever reason, decides to not cooperate and attend the hearing, then I still have the right to go ahead with the hearing, which is the last thing I want to do without your client. But as I gather now, you're not prepared to agree that if I decide that it should be in public after hearing from you, I don't have under any undertaking that your client will appear. Is that fair?
I'll seek instructions from my client once that decision is made, sir. I'm not in any position to predict what he's going to get to tell me in that regard. Certainly, I do not understand that he is obliged to be here through the entire hearing. He has the right, but not the obligation. I may be wrong in that regard. I'll leave it at that. So we're asking for an opportunity to explain the nature of the information we want to pass on to you. I will give you as much in a guarded fashion as I can, with the understanding that you may decide to make it public. And thereafter, if you agree to allow me to continue in private, I anticipate that I will then be able to give you a more enhanced version of the information that I possess from my client.
Mr. Cooper, how long will this take?
The information that I give you, sir, 5 or 10 minutes. I'm not talking about giving you a lot of information, but if you want an answer to your question, it's going to have to come in private.
No, I understand that. That's fair. Well, what I'm going to do right now is just adjourn the hearing for about 5 minutes and consult with my counsel, and then I will give you my decision.
Okay, so we'll recommence at 10:20 a.m. We'll now We'll now mute and stop video. 10:20 a.m. We will recommence. And Mr. Barclay?
Mr. Cooper, I've made a decision to give you an opportunity to make a presentation to me initially in camera. And once we've heard what the issues are, then I will have to make a decision whether it should be public or whether it should be in camera.
Thank you, sir.
And to facilitate that, Mr. Cooper, we have sent you a Teams invitation, which is not on this platform, to ensure confidentiality. We ask you to accept that invitation. We will be going to another room to take that call. And so we will now adjourn, if so please you, Mr. Barclay, to 11 a.m.
Yeah, I will formally, Mr. Cooper, adjourn the actual inquiry hearing to accommodate you, and we will then proceed at 11 o'clock. But in the meantime, we'll go ahead with our in-camera hearing.
Okay, we will now connect to you on Teams. Mr. Cooper, correct?
Understood, and we have the invitation.
Okay, thank you. We will now adjourn till 11 a.m. It's almost 11 according to our clock here. I see you're here, Mr. Cooper.
I am, yes, sir.
Okay. And Mr. Barclay.
Mr. Cooper, during the in-camera session, you indicated to me as a sole adjudicator that you were going to get instructions from your client. I now ask you, sir, as to have you received instructions and what are your instructions?
Indeed, sir. During the in-camera session, I indicated that my client was suffering from an emergent medical condition. You indicated that that was not something that you were prepared to keep from the public. I sought instructions on that basis, and I confirmed that my client is indeed suffering from an emergent situation, and we are in the process of seeking documentation from a doctor to confirm the circumstances, whether our client is in a state where he can attend and participate as he is permitted to do. In fact, unresolved is whether he's obliged to be here or not. We submit that he's not, but he certainly, I think, it would be common ground entitled to be here during the inquiry. Given the emergent nature, given the reality of the medical circumstances, not just from the pandemic, but generally speaking across Canada these days, we're going to need some time to get that medical documentation. We don't expect that you as an adjudicator could make an informed or proper decision in the absence of that. I can't predict because I have no control over the medical system in Yellowknife, and particularly Stanton Hospital, and therefore I'm suggesting a further adjournment to allow us to provide you with the necessary documentation. I'm proposing until 1 p.m., sir.
When?
1 p.m. 2 p.m. is good.
Actually, I appreciate your comments, Mr. Cooper, and I'm suggesting that we adjourn it not to 1, but to 2, which would be the regular time that we would proceed. But I think at that time, you're going to have to disclose publicly what this condition is.
I will disclose in accordance with my duties and the instructions that I get from my client at that time. I'll certainly be better informed and maybe in a possession to better inform you. I also note, sir, and I apologize for not noting this sooner, I wanted to ensure that we are paying due regard to our Chipewyan language interpreters. I don't see them on the screen, and I'm concerned, having dealt with many interpreters and translators in the North over the last 3 or 4 decades, that we are not paying sufficient attention to their needs and to ensure that they are able to maintain the pace that particularly counsel like me tend to maintain, and sometimes, particularly when you can't see the interpreters, sometimes a little too quickly. I'm certainly told that by court reporters on a regular basis these days, and I would urge you, sir, to make periodic inquiry of our Chipewyan interpreters. We'd also like to know who they are. It's something we've asked before, and it's not been disclosed to us. And certainly my client and others who prefer to communicate in the Chipewyan language, an official language of the Northwest Territories, that's something they have an entitlement to know. I'm not aware of any reason why their identity would be hidden. So we're asking if they maybe turn on the screen for a few minutes, but at the very least that we know to whom we are speaking, to our Chipewyan language speakers.
Well, thank you very much, and I appreciate your concerns. We realize, of course, the importance and the right of your client to have an interpreter in his own language, and we've made the necessary arrangements with the Legislative Assembly, very competent interpreters that are trained in that dialect. But I'm going to turn to my counsel. He was making specific arrangements for the interpreters, but I'm very pleased that what we've done to ensure your client's rights are protected.
Yes, we have 2 interpreters, Mr. Unka, UNKA, and Mr. Drygeese, GRYGEESE, who were sworn in by Ms. Anderson prior to the commencement of these proceedings. Anyone wishing to access interpretation need only access the interpretation button at the bottom of the screen, and by doing so, they will be directed and hear the interpretation in Chipewyan. So with that, Mr. Barclay, then we adjourn till 2 o'clock.
Yeah, I'm going to adjourn the inquiry now in view of your submissions, Mr. Cooper, in respect to the health concerns of your client. And I will deal with it at 2 o'clock.
Sir, if we may just, for the record, you may not be aware, but most Northerners can tell you where somebody originates from by their surname. So knowing only the surname of the two interpreters doesn't give us sufficient information. We would like to know who they are. I will assure you there are more than one Mr. Unka and one Mr. Drygeese to be found in the Northwest Territories, and we'd like to know the full names of the interpreters, please.
We will accommodate you.
And Ms. McPherson, Mrs. Anderson, Sheila Anderson, could you obtain that information for us for 2 o'clock?
Yes, I will certainly do that, sir.
Thank you, Ms. Anderson. So we stand adjourned till...
Yeah, the matter is now adjourned until 2 p.m. this afternoon. Thank you very much.
Thank you, sir.
Thank you.